In this video, we will be providing a history of the contamination at Camp Lejeune. In 1941, the construction of Camp Lejeune in Onslow County, North Carolina started. While the first base headquarters were located in Montford Point, it was moved to Hadnot Point in 1942. In the same year, the Hadnot Point water treatment plant was established to supply water to the Marines and residents of the camp. In 1952, the Tarawa Terrace water treatment plant started its operations for the growing population of the camp. The following year, ABC 1 Hour Cleaners opened a dry cleaning firm near Camp Lejeune. In 1953, the Hadnot Point water treatment plant was contaminated with different chemicals, including TCE, PCE, benzene, TCE degradation products, trans 1,2-DCE, and vinyl chloride from unregulated dumping of toxic wastes and industrial spills. Meanwhile, the Tarawa Terrace water plant was contaminated with PCE in 1957. A chemical used for dry cleaning. Investigations revealed that the contamination came from the adjacent dry cleaning firm. In 1974, Base Order 5100.13b was established, outlining the proper disposal of toxic wastes in the camp. Unfortunately, it was not strictly followed, and contamination continued. It was only in 1982 that the military was able to identify the chemical contaminants in Hadnot Point and Tarawa Terrace water plants. In 1987, 34 years after the contamination started, the two affected water treatment plants were finally shut down. However, it would take another 12 years until 1999 before the Marine Corps would notify Camp Lejeune residents about the health risks linked with the contamination. The first Camp Lejeune water contamination lawsuit was filed in 2009 by the wife of a Marine corporal who was a resident at Camp Lejeune for 3 years and developed non-Hodgkin's lymphoma. In 2012, all Camp Lejeune lawsuits were consolidated into multi-district litigation. Unfortunately, in 2016, a federal judge dismissed all Camp Lejeune lawsuits due to North Carolina's statute of limitations. In 2021, the Camp Lejeune Justice Act was proposed in the House of Representatives, aiming to enable individuals who resided at Camp Lejeune from 1953 to 1987 and who developed health issues to file a lawsuit, effectively rendering North Carolina's 10-year statute of limitation void. In February 2022, the bill was merged into the Honoring Our Promise to Address Comprehensive Toxics Act, or PACT Act, which added the provision of expanded healthcare and other rights for veterans, family members, and workers exposed to contaminants and toxic chemicals during their service in the camp. On August 2, 2022, the bill's final version was approved by the Senate, and on August 10, 2022, President Biden signed the bill into law. Veterans, family members, and workers stationed at Camp Lejeune for at least 30 days between 1953 and 1987, and who are diagnosed with the following medical conditions are eligible to join the lawsuit. Those with reproductive disorders, birth defects, neurological disorders like Parkinson's disease, and those who have developed different types of cancers, including leukemia, non-Hodgkin's lymphoma, and cancers like breast cancer, liver cancer, kidney, bladder, ovarian, prostate, cervical, lung, or esophageal cancer. Filing a lawsuit does not affect disability benefits. If you are one of the affected individuals from the Camp Lejeune water contamination, call Maxwell Law Group at 844-427-3031 today. We'll answer your questions and review your case at no cost.